President and the judges of the Caribbean Court of Justice.
All rise. Please take your seats. Thank you.
Yes, Mr. Hart.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, Dominica. Hearing of the appeal in CCJ Appeal Number 2 of 2018 between David George and Albert Guye. Can we have the appearances for the court, please? Thank you.
May it please the court. Pleasant good morning. Justin L. Simon, appearing for the appellant, and with me, Ms. Gina Dyer Monroe.
Yes, the appearance for the appellant, for the respondent.
Michael Bruni for the respondent, together with Ms. Lisa De Freitas.
Yes, thank you. And good morning, counsel. Mr. Simon, are you ready for us?
I am ready. May it please report.
Sorry for interrupting, but we have a technical problem here. We were just told that the matter will be proceeding by telephone, by audio only. However, we are cramped in the registrar's chambers. We have absolutely no space to even put down more papers. And we were hoping to be able to address the registrar just before your lordship will come out. To try to have a different arrangement, because we, on this side in Dominica, we really, on both sides, and not physically deal with the case clearly at this stage. And quite apart from that, the audio is not very clear. But we were hoping that some better arrangement can be made, whereby the entire appeal can proceed by video as previously arranged.
Okay.
What my learned friend has indicated, and I'm Gina Diamond speaking now from
Yes.
Dominica. It is quite an inconvenient position at this stage because, as my learned friend has expressed, the registrar's chambers are extremely small, and there is absolutely no space to even utilize or accommodate the records which we both have. And it is also very disconcerting for me as Counsel Mr. Simon, who leads me in respect of this matter, is on audio, and we are video, and we are here unable to have the benefit of the video for the court. It is a very unfortunate position, and we're wondering whether, in the interest of having the matter proceed, some sort of immediate alternative arrangements can be made amongst ourselves to ensure that we have the benefits of the video and proper audio.
Okay, a number of things. One is that everybody had the opportunity or the choice to appear personally at the court here in Trinidad. But of course, it is to your advantage in terms of time and cost to appear by audio or video. I don't know what alternative arrangements you are proposing. We can't stay here and propose alternative arrangements. We are hearing you clearly. I don't know if Mr. Simon has been hearing you. Mr. Simon, are you hearing them in Dominica?
I'm hearing them very clearly. Hold on.
In Antigua, well, hearing those in Dominica. Are you, Ms. Diane Monroe and Mr. Bruni, are you hearing Mr. Simon?
Here's Mr. Simon's initial presentation. Yes, when he had his appearance, we did hear him.
Right. We too heard you not so very clearly when you made that last intervention, Mr. Simon. But the point I'm making is this. We don't know what alternative arrangements can be made in Dominica. We are quite prepared to hear the appeal by audio conference only. Mr. Simon is able to appear both by audio and video. I don't know that that gives him any advantage. What is important is that we hear clearly the submissions that are being made. We are not going to be judging evidence and looking at body language and that sort of thing. So all that is necessary is for us to hear clearly the submissions that are being offered. I would take your word for it that you are in cramped circumstances in Dominica, but we don't know what alternative arrangements can be made. This matter has been set down for today, and we really would like to have it heard today. So, Mr. Bruni and Ms. Diamond, the ball really is in your court. I don't know if we are minded to adjourn this matter.
Difficulty in understanding. There's a lot of echo with your when you're not speak.
Okay. What alternative arrangements are you suggesting, Mr. Bruni?
May I insist the court, my lord, or do you want registrar and insist the court? The difficulty we have in court to have this matter heard today is the technician discovered that some of the new equipment set up just recently in the court earlier this year, because of our proximity to the sea, some corrosion has taken place behind some of the connections. So you will need 24 to 48 hours to change quite a bit of the connections. Once that is done, he has assured me that everything will be okay in court. But the difficulty is, because the way the system is set up in courts, my lord, you must have the video to work the audio. So that we can't hear the audio until the video is set up. And he assured me, my lord, that the video aspect of it should be under control within 24 to 48 hours once he has all the connections changed. And he will start working on that immediately.
I see. Okay. Yeah. Mr. Bruni, you spoke of alternative arrangements. Are there any arrangements which you suggest?
Is it possible that we can proceed from a various chambers?
Well, that is not a difficulty for us at all. Well, the court does not have a difficulty hearing you from your chambers. I don't know whether there's going to be any technical issue there. But, you know, if you have to repair to your chambers and then we try again to sort out all the glitches, another half an hour maybe would elapse, which means the appeal would start at what, 11:15? We have another matter scheduled for 2, and we were hoping that this matter would not carry us beyond 1 o'clock. How long would it take you to get to an alternative venue, to someone's chambers?
I would imagine 15 minutes.
Okay, well, where's Paul? And you're connecting now via a landline or by a cellular phone?
Landline.
By a landline. And it is proposed that you use a landline from your chambers?
We were thinking of using the same system that we used for our earlier cases, the case again, when we had case management and so on, that we can use the software that is linked to the CCJ.
Okay, so we will adjourn for 20 minutes. What's that? Right, so as soon as you get to your office, you call us. There's a number that they have that they will call. Paul, can you? Okay, so we will adjourn this matter to start at 11. Yeah?
All rise.
Mr. Simon?
Aye.
Counsel, court will resume at 11 a.m.
I got that.
Um,
I was really
you are to use the same connection?
yes. Use the same connection because
Yes.
I am here in my chambers, and they could do the same.
Paul? Said you couldn't- Yeah. Okay.
All right. So we'll resume at 11.
Yes, Take your seats.
Yes, I assume the appearances are as before.
As before, may the court accept that this Monroe is not with us.
Who's
We
not
have
with you?
no idea why not, but we are prepared to proceed in her absence.
Yes, well, can you please begin, Mr. Simon? Now, we are having it's not feedback as much as somebody's microphone is picking up a lot of extraneous noises. So it's stopped now, so let's hope it doesn't resume. Yes, proceed, Mr. Simon.
Much obliged to the court.
Now, before you begin, it's 11:15. How long did you intend to be, Mr. Simon?
I would think half an hour, may it please the court.
That would be excellent. Yes.
My lords, my lady, this appeal raises 4 issues of law. 1. Does Section 2 of the Real Property Limitation Act not allow for the acquisition of a prescriptive title by a squatter to land that he has occupied for a period of 12 years without any interruption by its owner? The second issue, does a prescriptive title by the application of Sections 2 and 10 of the Real Property Limitation Act not create an estoppel against a landowner who seeks to bring an action or suit to recover the land or rent therefor? Thirdly, has the Real Property Limitation Act or any provision thereof been impliedly repealed by the Title by Registration Act to the effect that only land held by common law deed is subject to Section 2 of the Real Property Limitation Act? And finally, does not Section 33 of the Title by Registration Act in fact entitle a squatter who has acquired or claims to have acquired a prescriptive title to request of the Registrar of Titles to have a certificate of title issued to him in lieu of the registered proprietor, while forbidding the squatter from maintaining any suit in regard to the land until he has obtained such a certificate of title? May it please the court, there is no issue on the facts which gave rise to this case, now on appeal to this distinguished court. As was stated by the respondent in his submissions at paragraphs 1 to paragraphs 4, the appellant and the respondent are owners of adjoining lands. The subject matter of this appeal is a strip of land occupied by the appellant and his predecessor in title for more than 12 years. And it is part of lands owned by the respondent and his predecessors in title under a certificate of title issued in accordance with the provisions of the Title by Registration Act. The court is respectfully asked to bear in mind that the appellant is not challenging the certificate of title of the respondent. The appellant is doing no more than challenging the right of the respondent in seeking to obtain possession of that strip of land that the appellant and his predecessor in title have been occupying undisturbed for over 12 years.
But just now, Mr. Simon.
And we all know
just now, Mr. Simon.
Yes,
if you're not challenging the certificate of title that is deemed to be indefeasible, how can you then claim a portion of the land that is contained in that title?
My Lord, we are not making any such claim. That counterclaim had been made before the High Court. It was dismissed, and we are not on appeal in respect of the counterclaim. Our claim is a defense. We are saying that we raise Section 2 of the Real Property Limitation Act as a shield, because that section prevents, in our humble submission, the landowner, who is the respondent with the certificate of title, from making a claim either in respect of possession of the land or in respect of rent in respect of the land. So that our claim, we're not making a claim for title, because that is addressed under Section 33 of the Title by Registration Act. What we are saying is that notwithstanding the ownership of the respondent by virtue of the certificate of title, the respondent is precluded, is stopped from bringing that action to claim possession of the land. And our authority for that is Section 2 of the Property Limitation Act.
So his certificate of title is not what the Registration Act says that it is.
You mean the Title by Registration Act?
Yes.
Yes. You see, he has a title, and we are not running away from that. But if we look at the meaning of the word indefeasible, which is contained in the first schedule to the Title by Registration Act. And if I may read for your lordships, indefeasible, the word used to express that the certificate of title issued by the Registrar of Titles and the notings of him thereon cannot be challenged in any court of law on the ground that some person, other than the person named therein as the registered proprietor, is the true owner of the land therein set forth, or on the ground that the mortgages or encumbrances in the notings thereon are not mortgages and encumbrances on the said land, except. So there are two exceptions in respect of the term indefeasible. One, except at the ground of fraud, consider the issue of the certificate of title.
Sorry, we're not hearing you clearly.
We're seeing,
I think that
it's just 1 more minute and then we are done. She said she's going to hang up now. Can she? Yes. Is the audio working?
we're hearing a conversation going on in the background. I think that
You mute.
Okay.
okay, Mrs. Diamond, I think you'd have to mute your computer. Okay, the persons who are not speaking, who are viewing via a computer screen, would have to mute their computers when they're not speaking. Or otherwise you get a feedback. Yes, Mr. Simon, please continue.
So I am submitting that the term indefeasible, I'm still having that feedback.
Yeah, we're still having the feedback. If you're not speaking, make sure to mute your computer.
May I ask Ms. De Freitas to quietly go outside and call Ms. Dyer and inform her that she needs to mute her computer?
Yes, it's all muted now. We're hearing you very clearly. Oops.
Much obliged. So we are respectfully submitting that the word indefeasible allows for two exceptions. Two exceptions which allow the certificate of title of the landowner to be challenged. We are concerned here in respect of the second exception, and that is that the title of the registered proprietor had been superseded by a title acquired under the Real Property Limitation Act by the person making the challenge.
Okay, and does the Title by Registration Act go further and indicate how a title under the RPLA is acquired?
It does.
In
Under
Section 33.
33. Yes, may it please allow.
So that you have to read the first section along with Section 33. Now, your client, does your client have a title under Section 33?
The appellant has not made any such application.
So he has no title under Section 33, and therefore,
No title.
does he fall under the exception that you have pointed out?
He falls under the exception because, notwithstanding the fact that he has no title under the Title by Registration Act, he has acquired a title under the Real Property Limitation Act. Because if we look at both the definition of indefeasible as well as Section 33, they speak to a title acquired under the Real Property Limitation Act, not a title acquired under the Title by Registration Act. In fact, it is precisely because the appellant has obtained a title under the Real Property Limitation Act that he is now allowed under Section 33 to seek to obtain a certificate of title in lieu of the respondent's certificate of title.
So, as far as you're concerned, the appellant has a title, but he has no certificate of that title.
May we wish to make Millard respectfully. And the title which he has now and which he has acquired has been acquired as a result of Section 2 of the Real Property Limitation Act, in that he has been in undisturbed possession of that strip of land for over 12 years.
But let's get back to the definition of indefeasible. That definition speaks to, as one of the exceptions, a certificate of title or a title.
It is, as an exception, the title of the registered proprietor, so that is the title of the respondent, had been superseded by a title acquired under the Real Property Limitation Act, not a title acquired under the Title by Registration Act, because they're two separate and distinct titles.
Mr. Simon, if we were to put aside for the moment the concept of indefeasibility and look at the nature of the rights which inhere in the owner of the title, the person with, if you will, paper title to the land. Section 10 of the Title by Registration Act gives a description of the rights of that owner. And it would seem to me that those rights would be inconsistent with somebody else claiming what in common parlance would be regarded as squatters' rights. Would you not say?
I would respectfully indicate or state that the right which has been acquired by the registered proprietor, the certificate of title, is absolute. And it cannot be qualified or limited by any limited terms of qualification in the certificate of title itself. So we are not running away from the fact that the respondent has a certificate of title which gives him ownership. What we are saying is that in respect of the appellant who has occupied the land for more than 12 years, the certificate of title holder, the respondent, cannot bring an action against the appellant.
But if he cannot bring such an action, that would seem to me to be counter to the clear wording of Section 10. Because Section 10 says that he has the fullest and most unqualified right which can be held in land by any subject of the state under the law of Dominica. And clearly one such right must be the ability to evict somebody who is squatting on his land, surely.
Squatting on his land until such person has been squatting on his land for the period of 12 years or more.
Yeah, but Section 10 doesn't say that.
What I am submitting is that one has to look at the term indefeasible and marry that meaning with the rest of the act.
Mr. Simon, looking at that terminology, that definition, it says the certificate of title cannot be challenged in any court of law on the ground that some person, other than the person named therein as the registered proprietor, is the true owner of the land. So a title, certificate of title, cannot be challenged on that basis, with two exceptions. But I think you started out by saying that you're not challenging the certificate of title of the respondent. You are kind of defending against the respondent, but you are not challenging at this point in time the certificate of title. Is that correct?
You're correct, Malad. We are not challenging at this point in time, because for us to challenge the title, we would have had to have made an application under Section 33 of the Act. Let me go further. The shield which the appellant seeks to enforce is that in respect of the appellant himself, the respondent cannot bring a claim for possession of the property. That does not stop the respondent from bringing a claim against any other person.
Sorry.
That is the right which he has. The right of the respondent is only qualified insofar as Section 2 of the Real Property Limitation Act has allowed the appellant to acquire a title.
Mr. Simon, if I could take you back, if I could take you back quickly to your concern with indefeasible and the specific clause to which you refer, that the title of the registered proprietor had been superseded. How does supersession occur in the absence of Section 33 application or registration, sorry? How does the title which is acquired under the Real Property Limitation Act, how does it supersede the title under the registration by Title by Registration Act? Because there has to be a supersession. How is it superseded?
We first of all have to recognize that the title acquired under the Real Property Limitation Act is a title which is separate and distinct.
But it must still, but mustn't it still supersede the title of the registered proprietor, especially given Section 10, as referred to by my brother Anderson?
If you look at the wording in respect of the title, in the word indefeasible, it talks about superseded by a title acquired under the Real Property Limitation Act, not a title acquired under the Title by Registration Act. It's a title acquired under the Real Property Limitation
Yes, but
Act.
the question is, what is it that denotes the acquisition of that title?
Two,
So as to supersede.
So that it supersedes the certificated owner's title.
the squatter is on that particular study. It does not. But in respect of the squatter who has been there for 12 years undisturbed or more, he has acquired a title under that.
Mr. Simon, even if it is conceded that he has acquired a title under the Real Property Limitation Act, this title still need to supersede the title of the registered proprietor if you want to bring it within the exception in the definition of indefeasible.
That is why we're stating that this title by registry, the title under the Real Property Limitation Act cannot be used as a sword. Mm-hmm. It can only be used as a shield.
But this is a very colorful and very colorful use of language, but it doesn't really, in my respectful view, Mr. Simon, help this court to understand how this title. It is given that a title can be acquired under the Real Property Limitation Act, but even the acquisition of that title doesn't answer the question because it still has to supersede the title of the registered proprietor, especially given what the remainder of the Act has to say about the title of the registered proprietor.
Let us look, Malad, at Section 33 very carefully. Where any person has acquired or claims to have acquired under the Real Property Limitation Act the ownership of land brought upon the operation of this Act. So, Section 33 proceeds on the basis that there has been an acquisition of land, acquisition of a title which is acquired under the Real Property Limitation Act.
Or a claim to having acquired the land.
A claim made, that's right, either a claim made or acquired. And it goes on to say, he shall then present a request to the Registrar of Titles to have a certificate of title issued to him in lieu of the registered proprietor.
Isn't this
So
how,
that-
isn't it, Mr. Simon, isn't section 33 telling us how this supersession can take place? Or how it must take
Supersession.
place?
How it must take place
Yes.
so that this court
Has a
obtains a
certificate,
title
but he's not
on
wanting
the
that.
Statutory Registration Act. But what we have to recognize is the condition precedent to that application must be that he has either acquired or he claims to have acquired a title under the Real Property Limitation Act.
Well, the answer to that,
That's the precondition.
yeah.
So we're talking about two separate and distinct titles.
One
If
way,
it were not so,
yes,
if it were not so, the section would not read as it does, where any person has acquired or claims to have acquired under the Real Property Limitation Act. It's only when he has acquired such land, such title, that he can now present to the registrar an application to obtain a certificate of title under the Title by Registration Act.
you're grounding the ability of the appellant to use the sword, as you colorfully put it, on the basis of Section 2 of the Real Property Limitation Act, right?
And this is what it says. After the commencement of this act, no person shall make an entry or distress or bring an action or suit to recover any land or rent, but within 12 years next,
Yes,
after the time which
Yes.
the right to make the entry or distress or to bring the action or suit has first accrued to some person to whom he
yes, Senior Counsel, we have it, we have it. The question, though, which I wanted to put to you, is whether this section applies to registered land. Because I think the difficulty we're having is that to apply it to registered land runs the risk of inconsistency with Section 10, as I mentioned earlier. So will that difficulty or potential inconsistency not disappear if we were to restrict Section 2 to unregistered land? Do you have any cases or authorities that say that Section 2 applies to registered land?
I do not have any authority that says so except the Title by Registration Act itself, because the Title by Registration Act, both in the definition of indefeasible and the wording of Section 33, expressly acknowledges that one can have a title under the Real Property Limitation Act.
Yeah, but
So what actually has occurred is that the Court of Appeal accepted the submission of the respondent that the Title by Registration Act impliedly repealed the Real Property Limitation Act. And I respectfully submit that there has been no such repeal, neither expressed or implied.
okay, let's not necessarily go down the road of repeal. The point is, you have two acts. One follows the other. These two acts have different policies that inform them. Would you agree that the policy that informs the later of those two acts is a policy to produce a certain amount of certainty as to ownership of land?
I agree.
And if that is so, then, and that act provides a process for a certificate of title to be superseded, then isn't it logical that you should adhere to that process in order to supersede a title that someone has a certificate for? Would these two acts, if there is any tension involved in them, and it seems to me that there is some tension involved, because on the one hand, you have an act that says if a squatter is on your land for 12 years, you're out. And on the other hand, there is an act that says once you have a certificate of title for land, you can go to a mortgagee, and that mortgagee only has to look at the register to satisfy himself that you are good to go with this land. I will advance you monies on it. So that there's a tension that exists between these two things. And it seems to me that Section 33 resolves that tension in a particular way. It doesn't repeal the RPLA, but it tells a person who is squatting for the required number of years what that person must do in order to supersede the title of someone who has a certificate.
Let me say two things in answer to that, Lord. One is that the Section 2 of the Real Property Limitation Act does not supersede the certificate of title held by the respondent. What it does, and that is limited only to the squatter who has been there for 12 years or more. It stops the owner of the land from bringing an action or suit to recover the land from that squatter.
Yeah, but would that reintroduce a host of uncertainties as to the efficacy of a certified title holder's ownership?
But respectfully, I do not think it does. Because whilst the Title by Registration Act says that the certificate of title is indivisible, it qualifies that by placing as an exception that the title can be superseded by a title acquired under the Real Property Limitation Act.
So,
let
as
me put it this way.
my brother Burgess pointed out, the crux of this matter is, what is it? What is it that supersedes a certified owner's title? What is the event or the thing that supersedes that title?
Yes, that is obtaining the title. Obtaining title. I have no problems with respect to that.
And that is done through, Section 33, correct? Obtaining the title.
Person A and person B are in occupation of land belonging to person C. Person A has been in occupation, undisturbed occupation, for 12 years and more, whereas person B has only been there for 8 years. Person A dies. The person C who owns the land can get person B off the land because he has not been there for 12 years. But in respect of person A, who has been there for 12 years, he cannot bring a suit against person A. So that what the Real Property Limitation Act does is to create a shield in respect of he who has occupied the land for 12 years and more. In respect of the rest of the world, there is no problem.
Mr. Simon, may I refer back to the exception that you have highlighted to us? In Section 33, Section 33 doesn't seem to disagree with you that a title has or may be acquired under the Real Property Limitation Act, Section 2. It doesn't dispute that. It doesn't, and in this case, it may very well be that a title was acquired under the Real Property Limitation Act. But the only exception which is relevant on your own reading of the relevant encumbrance definition is a title which is acquired under this Real Property Limitation Act, which has superseded the title of the registered proprietor. And as my brother president has pointed out, Section 33 appears to be the section which defines or describes the event that has to happen for supersession to take place. Am I right in thinking that this is the way that clause should be interpreted?
With respect, I do not agree, Mala. When we look at Section 53, what Section 53 does is that it provides that the squatter shall not be entitled to maintain any suit in regard to the land until he has obtained a certificate of title thereto. That is the effect of Section 33. So that the squatter cannot brandish a sword until he has acquired title under the Title by Registration Act. What we are saying is that in this case at bar, we are not brandishing a sword. We are raising a shield. Because if we look at the Real Property Limitation Act, the only section in that act which, to my mind, respectfully, makes provision for the obtaining of a title under the Real Property Limitation Act is Section 2. Section 2 is the only section under the Real Property Limitation Act that qualifies the rights of the absolute owner of land to recover that land or rent.
Okay, Mr. Simon, I think we all clearly, I think we all clearly understand your argument. You're saying that Section 33 only affords the squatter the opportunity to use his claim of adverse possession as a sword, but it doesn't deny him the right to use it as a shield if the conditions in Section 33 are not fulfilled. I follow that argument perfectly. What I would like you to tell me is, as a matter of practice, if someone has been in adverse possession or claims to have been in adverse possession for more than 12 years, and he wants to dutifully follow Section 33, he goes and does what Section 33 says he must do. Can the person who has a certificate of title at that point prevent him from obtaining a certificate that would supersede the certificated owner's title? How does that system work in practice?
Cannot, because what Section 33 goes on to say is when a request for such a certificate title is presented to the registrar shall state a case to the court, so that the court will then make the determination as to whether or not that squatter can or has established that his right of occupation undisturbed for the past 12 years.
I see, okay. And when the matter is, when a case is stated to the court, I assume that both sides, when I say both, I mean both the squatter and the person who has the certificate, can present evidence before the court to determine whether the squatter has satisfied the provisions of the Real Property Limitation Act. Is that correct?
Indeed. It did.
Okay.
If I understand you correctly, you're saying this. In this particular case, the judge in the High Court found that there was adverse possession for more than 12 years, and so he should have afforded the appellant the shield which flows from that. And if he wants to go further, then he needs to make use of Section 33 of the Registration Act and file some application with the registrar. But as I understand it, if he already proved before Justice Cottle that he had this adverse possession of more than 12 years, if that has been already proved, then I suppose it would be more of a formality to get the title from the registry, because he already proved that he acquired a title under the Real Property Limitation Act. Is that correct, or is that not what you're saying?
Respectfully, that is the point which I wish to make.
Well, if that is the case, then if that is the case, Mr. Simon, and I'm just dealing with hypotheticals here, if your appeal is dismissed, you then still have the right to apply to the Registrar of Titles to secure your certificate, don't you?
It's my option. That is an option which I have. I may or may not exercise it, but I do have the right to make that application by virtue of the fact that I have a title under the Real Property Limitation Act. But what the Court of Appeal and the court below did was to say that you must have that title, you must have applied for the title and supersede the title of the respondent first. And I'm saying no such thing. There are two independent rights. And in fact, what the right way we're exercising is the shield which has been given to us by Section 2 of the Real Property Limitation Act.
Yeah. Mr. Simon, the way I understand your use of Section 2 shield argument, it appears that there would be then no distinction between unregistered land and registered land, so that Section 2, as I understand your argument, would apply to both. Would there therefore be any advantage in having registered land?
Yes, there is an advantage, because unregistered land, it's a common law deed. And in fact, that would have to be established in terms of your occupation of the place. It's difficult. And that is why we have had a change, not only in Dominica with the Title by Registration Act, but also in Antigua, where we now have the Registered Land Act, where all land has to be registered. So it makes a difference. And our submission is that the Real Property Limitation Act applies to both the common law deed as well as the certificate of title under the Title by Registration Act. And what this Title by Registration Act does is that it not only recognizes the title obtained under the Real Property Limitation Act, but it allows you, the squatter, the opportunity to make an application to get a title in substitution of the owner.
Yes, but I think we have your arguments, Mr. Simon. You're saying that the Title by Registration Act does not deprive you of the opportunity to use your adverse possession as a shield against the attempts by the certificated owner to eject you.
The Section 2 still applies to land which is held under the Title by Registration Act.
Yes.
Because nowhere at all in that act has that section been repealed, either expressly or by implication. Au contraire, it has been recognized under Section 33 and under the definition for indivisible.
Okay. Is there anything further you need to tell us?
Well, that apart, I wanted to just draw the court's attention to the case of Tulsi Prasad, which is a judgment from this very court.
Yes.
And in fact, in that case, the appellant had sought a declaration that he had acquired a prescriptive title under the Title to Land, Prescription and Limitation Act in Guyana by undisturbed adverse possession for over 12 years. And the courts held that if a dispossessed landowner was to stop time running in favor of the person in undisturbed possession of land, he had to bring a case of possession against that person prior to the 12 years. So even in Guyana, the issue of the prescriptive title runs on the same principle: undisturbed possession for over 12 years. Once that is established, then the squatter has prescriptive rights. And I think that case makes that abundantly clear. And I would respectfully refer to it and ask your lordship and ladyship to examine that particular case and review the legal reasoning of the court.
Yes.
The other case which I wish to refer to is the case of Graham Davis versus Charles. That's a Privy Council decision emanating out of Antigua. What our Registered Land Act did was to provide that the sorry, just 1 second. That the acquisition by long possession, although it is not recorded in the register, it nevertheless remains as a what was the word that was used? And in fact, it is on that basis that possession was being sought, because it allows for that to be registered as an overriding interest. And I would refer the court to page 197 of the Privy Council judgment in 43 West Indian reports. And it provides that Section 28 of the Registered Land Act, at F, provides that rights acquired or in the process of being acquired by virtue of any law relating to the limitation of actions or by prescription, although not noted on the register, is considered to be an overriding interest, which then allows the squatter with the overriding interest to make an application to be registered under the Registered Land Act. So that our modern land law, whether in Guyana, here in Antigua, accepts and acknowledges the continued application of the Real Property Limitation Act. And as I've indicated, that it is a shield insofar as it prevents the landowner from taking an action against a squatter of over 12 years standing. But it does not prevent the landowner from taking action against anybody else. And the landowner will only be dispossessed of his title if the squatter makes an application under Section 33. But he does not have to make an application under Section 33 to be able to use the shield afforded him under Section 2 of the Real Property Limitation Act. That is the substance, respectfully, of my submissions.
All right, thank you very much.
I have one practical question, Mr. Salmon. It is stated by you that although Section 33 of the TBR speaks of application for a certificate of title by prescription, no rules, regulations, or procedures for sub-application has been enacted under that act. There is no time limit given for such application, nor information as to how such application is to be made. So my question is, does it happen that these applications are made, and how are they dealt with?
The applications are in fact made and can be made because it's simply an application to the registrar. And that is why it indicates that the registrar shall state a case to the court, so that the court will then hear both sides and determine factually whether the squatter who is making that application, in fact,
Has a title.
acquired a title.
So that until a court makes that determination, it's all up in the air.
I wouldn't say it's up in the air, but until the court makes that determination, the original landowner continues as the title holder of the land. And his only restriction is to bring an action in respect of the squatter of more than 12 years.
Yes. Yes. Okay, I think you have exhausted your time, I'm afraid, Mr. Simon, and we thank you for your submissions. I think we understand them, and we will hear from Mr. Bruni.
A copy of my statement. That would assist. I could make this available.
Mr. Bruni, are you hearing us?
Yes, very clearly. I wonder if Mr. Simon is you. Very well. Okay. Hello?
Hello?
Yes,
I think somebody needs to mute their microphone. I don't know if it's you, Mr. Simon.
No. Oh.
yes.
Yes, proceed, Mr. Bruni.
Yeah. Just to answer the question that
No, somebody still has to mute their microphone. We're getting a terrible feedback, some noise. Okay, that's a little better.
Basically, the practice under Section 33 is that the applicant would state a case to the registrar. The application would be advertised in the local press, and a 6 weeks period would be allowed for objections. And then the registrar would state a case to the judge. If there's any objection by way of caveat, the court would hear both sides and then determine whether or not to grant, to cancel the title of the registered proprietor and give the title to the squatter.
Okay, now, in that process, is the registered title owner able to also lodge objections? I would imagine so.
Very well. He is entitled to lodge objections. And in fact, he would be the one most likely in possession of the title. So there can be no change of title if the title is not called in. So he must have some kind of notice of the application.
Can a title, can during those proceedings, can his title be superseded over his objections?
Not until the determination by the court.
I know, yes, but the court can determine that he has lost his title because of the squatter's adverse possession. Is that it?
That's correct. That's correct.
I see. Okay.
I'll put it another way. What are the factors that the court considers? Is it just whether the requirements for adverse possession have been met? Is that the universe of factors that they consider? Yeah.
Yes, whether there is possession to the exclusion of the world of the owner, and if the person has occupied and used the land as his own for 12 years.
Does it matter who comes to court first?
Well, that is our case. It does.
Right.
Our case is that so long as the registered proprietor is registered as the title holder, then his rights are the fullest and most unqualified rights. And the Title by Registration Act itself, by Section 6, says all land brought under the Act shall be governed by the provisions of the Title by Registration Act. Our case is that so long as the registered proprietor holds the title, he has the fullest rights. Right. And if a squatter wants to displace him, he must follow the procedure in Section 33.
So what happens now if the appellant, let's say you win your case and the appellant says, okay, well, I will go to the registrar and invoke Section 33 because I have been there for more than 12 years, adverse possession, that in fact that has been established by a judge in the High Court, and so please give me my title. How would that work out?
Well, from a practical point of view, if we look at it in theory, by the judgment in 2012, I believe, his possession would now have been interrupted because there would have been a declaration by the court, basically that the registered proprietor is the owner of that particular piece of land. So this would have issues in itself.
So in a sense, as you say, it's who first reaches the court with an action.
Yes. Because if we look at the whole scheme of the registration by Title by Registration Act, it is to the world. It brings about certainty of title. And that is why Section 33 says that until such time as the registered proprietor is displaced, his title is displaced, the squatter cannot maintain suit. And this is the basis on which both the High Court and the Court of Appeal decided this case. The registered proprietor has the unqualified right, fullest right over the land. You as a squatter, you're occupying, you are in possession for 12 years. We have on the one hand, we'll see in the registered proprietor as the owner. In order to displace him, to displace his title, you must apply to the court. You must have your title revoked.
Yeah, but what Mr. Simon is saying is that he doesn't necessarily want to displace your title. He simply wants to stop you from bringing an action against him.
Well, Mr. Simon, that is Mr. Simon's argument, that he uses Section 2 to say, hold on, brother, I have been here for 12 years, you cannot displace me. But he forgot that under the Real Property Limitation Act, Section 10, which incorporates, Section 10 incorporates William III and IV statutes from England. So the registered proprietor.
Sorry, go that again. There was a little bit of static. It incorporates the acts in William
the third and fourth William IV. Yes. Right, that is Section 10. And this particular act, which is referred to in the submissions of the appellant, provides for the automatic extinction of the rights of the registered proprietor. The title is extinguished by the provisions of Section 10. So that we have two matters to consider. The question of the procedure which is necessary under Section 33, and the fact that by virtue of the 12 years having elapsed, right, the Act says that anyone who is entitled, so to speak, to a prescriptive title under Section 2, basically the that particular title of the title of the paper owner, the owner, is extinguished by Section 10. So that is why the appellants are arguing that this whole limitation provisions are contrary to the whole concurrence principle, the whole question of certainty of title. So the two acts cannot coexist. We're not saying that the Limitation Act does not apply to land in Dominica. It does. But where there is a registered title, because of the rights that have been established by the Act, the certainty of title, the provisions of Section 6, Section 9, I believe, if you look at the various provisions and the definition of indefeasibility, which basically says until you have made the challenge under Section 33, the registered proprietor has the fullest right. So our case is that there must be compliance with Section 33, and Section 33 says not just that you must bring an action. Sorry, let me just get the relevant section. Section 33, General Commission. Section 33 says where any person has acquired or claims to have acquired under the Real Property Limitation Act the ownership of land brought upon the operation of this act, he shall present a request to the registrar of titles to have a certificate of title issued to him in lieu of the proprietor in the original certificate of title, and the person who has acquired, same language of the definition of indefeasible, the person who has acquired or claims to have acquired the ownership shall not be entitled to maintain any suit in regard to the land until he has obtained a certificate of title thereto. So in other words, this brings the title by registration. It incorporates the limitation statutes into the whole scheme of the Title by Registration Act. The fact that the registered proprietor has the fullest rights. So what we have is a situation where if somebody claims to be in possession and claims to be entitled to the land, he must first acquire title before he can assume the rights of the registered proprietor.
And the title, you say, is acquired through the procedure established in Section 33.
In Section 33.
Now, the difficulty I have, you see, I follow fully what you say when you say that everything depends on who gets to the court first. That person starts the action and the court adjudicates on that person's claim. But in this case, there was a counterclaim. So in a sense, both parties were presenting their respective cases at the same time.
Yes,
so,
and that is what... Sorry.
Go ahead, yes.
No, I was saying that is why the whole argument of the shield and sword fails. If you're saying that the squatter can use his possession as a defense, what prevents him from filing a counterclaim and getting declaration at the same time? Mm-hmm. So in other words, if he goes through the procedure where through a civil suit he can acquire title by a counterclaim, then this would be contrary to the provisions in Section 33. And that's the remark that was made in fact by the Court of Appeal in the case of Burton, Revere, and Durand, where although the registered proprietors themselves were not the parties to the action, the court made the point that a judge could not have ordered the issuance of a prescriptive title until such time as there was compliance with Section 33. Mm-hmm. This point is also made in the Privy Council case. I think the same case that my learned friend quoted, the Graham Davis case, right? And this was quoted with approval by the learned judge, Justice Baptist, in the actual Court of Appeal decision, where the Privy Council stated, and that is on page paragraph 41 of the Court of Appeal decision, the Privy Council in the Graham Davis case. Having considered the provisions, the Privy Council stated, it is apparent from these provisions that a title registered under the Title by Registration Act could only be superseded by the prescriptive title acquired under the Real Property Limitation Act, where the court had directed the registrar to issue a certificate of title to the person claiming under Section 34 of the former Title by Registration Act. Now, Section 34 of Antigua at that time was identical in paramateria to the Dominica Section 33. So that basically...
Mr. Bruni, now, I'm trying to get this. Suppose the appellant would have presented his request on the basis of Section 33 to the Registrar of Titles. And after he had done that, but there was no decision yet on that request. After he had done that, you would have filed your case, as you did. How would it go then? Because he would say, yeah, well, I presented a request to the registrar, it's now going to be heard, and I will be able to prove that I have had first possession of this strip for more than 12 years. Okay, I cannot make that. I do not have the title yet, but I'm now in the process of getting it. How would that go?
Well, because I would be representing the appellant, I would determine I would contest the application of the squatter. So, for example, in that particular situation, the appellant would have applied to the registrar.
Yeah.
I would have had notice as the registered proprietor that he's claiming my land.
Mm-hmm.
So I would contest it right there and said, hold on, brother, you have been occupied the land, but with my consent or with the former proprietor's consent.
Yeah, but suppose he would be able to prove it was not with consent, it was really adverse possession for more than 12 years. In that case, as I understand it, in that case, the court would probably rule that he would get a certificate.
That's correct.
Okay. So
in respect of the time.
So it really comes down to who is first now. If he had been first with presenting the request to the registrar before you sued him in this procedure before Justice Cottle, then he could have proved that he had this adverse possession for more than 12 years, well, then he would have gotten that particular strip of land or the ownership of it. But you were first, and you say, well, I was first, and so that is bad luck for him.
But it's not just being first. I am the registered proprietor.
I know.
I have a certificate of title in the bank to secure my loan.
Yes.
You understand? The bank is dependent on the conclusiveness of title to decide this is my land. I have security.
Sure.
You understand? Only the fact that somebody says, hold on, you don't own the land because your title has been extinguished. Because we have to look at Section 2 together with Section 10 of the Real Property Legislation.
So, in other words, the institution of your action interrupts his adverse possession, assuming that he was in adverse possession.
That's correct. That's correct.
Do you have any authorities that support that view?
Not readily available, but I think it's universally understood.
No, well,
We can always...
no, I was thinking of in the context of Section 2. The same question I basically asked of Mr. Simon. You see, Mr. Simon is arguing for a particular interpretation of Section 2. And I asked him earlier if there was any cases that supported him. He said he couldn't think of any. Can you think of any cases that support your interpretation?
Yeah, well, my lord, the Judge and Rosalie Estate case is on point, and this is one of the cases that was applied, and it is in fact binding authority on Dominica. All right, it is one of the cases that was applied by the Court of Appeal in the instant case, where here we had a squatter who was claiming to be entitled to land but had not yet acquired a certificate of title. The court held that while he did not have a title, although he might have been entitled, to own the land, but until such time as he had proceeded, he had complied with Section 33, he was only somebody qualified for a title, right? I think to use it, if we can get the actual words of the section, which we have in our submissions, it is very important. It is in our submissions, Judge against Rosalie Estate, section that is referred to in paragraphs 40 to 42 of our submission. All right? The Court of Appeal, where it was held that the certificate of title issued to the respondent company gave the company an indefeasible title to the land, and whatever inchoate rights were then possessed by the appellant or his predecessors in title, they were unenforceable while the company enjoyed the indefeasibility granted by the certificate. At page 409 of the judgment, right, the court said that the appellant derived title under the certificate of title issued on October 9, 1962. Until then, he was a person qualifying for title by adverse possession, but powerless to defeat the registered proprietor of the land. So this is in fact the authority, this is the leading authority and the binding authority on the High Court of Dominica. All right, it was a decision of the British Caribbean Court of Appeal in 1965 when Dominica was under the West Indies Federation. So that basically that is our
Yeah, okay.
what we are doing right now.
That looks useful. Thank you.
Yes. Is there anything else, Mr. Joni?
Yes, there's other peripheral matters. The appellant in their submissions seem to place a lot of emphasis on the meaning of the word maintain, as to whether maintain an action means commence an action. We respectfully submit that maintain should be used in its ordinary meaning, and that's maintained in the context of Section 33. It should be given its ordinary meaning. In the Judge versus Rosalie Estate case, for example, that I just quoted, the appellant was the one who brought the action, and the appellant seems to rely on that to suggest that it means that the word maintain means that the person must commence an action. But we have the situation where in the Birtland Revere case, which is also a Court of Appeal case of Dominica, the court remarked at paragraph 6 that the defendant ought to have brought a suit under Section 33 in order to maintain an action. And even in the Judge against Rosalie Estate, counsel on both sides had different interpretations of the meaning of that particular word. In the Title by Registration Act, maintain is used in Section 33. But in other sections, and I refer to your Lordship, Section 19.1 of that Act, 19.1, where the Act provides that anybody aggrieved by the issue of a certificate of title may, with the consent of the minister, institute a suit. So the words institute is used as opposed to the word maintain for commencing an action, and given in the definition of the indefeasibility of the indefeasibility provisions in the schedule of the Act, in the last two lines you have the word bring an action. They don't use the word maintain. They specify you can bring an action, and the word bring is repeated in sections 1082 and 141. So we're asking the court, in considering the effect of Section 33, to treat the word maintain as meaning just what it means, uphold, continue, and prove. Our other points are referred to in our submission. We respectfully would rely on our submission in terms of any other matters to be brought up.
I assume you're deliberately on mute.
Sorry. Yeah, we did that accidentally. We just would like to mention two other aspects. The guidance case that my learned friend referred to, like a lot of the other authorities cited by counsel,
refer to jurisdictions where there are no similar provisions to the Dominica legislation. And most of the authorities dealing with the torrent system will indicate that the system is different in different jurisdictions. And one must look at the particular jurisdiction, at the legislation of the particular jurisdiction in interpreting the law. So that the Guyanese case that we heard a while ago, and most of the other cases cited by counsel from Belize, from Grenada, and from some other jurisdictions, they would not apply because Justice Baptist himself pointed out in the Court of Appeal decision that the provision of Section 33 and the indivisibility of title was actually unique to Dominica, and I think some of the Leeward Islands when the legislation was first enacted in 1865, I believe. So that we would like the court to take that into context. Also, the other point that we'd like to make in terms of the High Court decisions that were actually cited by my learned friend, we asked the court to adopt the approach that was taken by the St. Lucia High Court Justice Smith in terms of dealing with matters that have not been in terms of dealing with the question of implied repeal. Basically, my lord, we have the case. We will give you the reference in a while. Why my learned friend looks it up. But there is a St. Lucian case. I will just talk about it while my learned friend looks it up. It's Clan Virons. We will get the reference in a short while, but just to save time, in the interest of time, where basically there was a provision for the rectification of the registrar by persons who had claimed to be in adverse possession in the St. Lucia, whereby it required an application to the High Court. The court would actually make a declaration and direct the registrar to issue the title. This was in the St. Lucia Code, I believe, in 1990. In 1984, the St. Lucia passed the Real Property Act, or the Land Registration Act, which removed the need for the matter to go to the High Court judge. It happened that the practice continued to have the process go through the High Court judge until one particular appellant challenged it. And Justice Smith, in making the decision, said the fact that it had continued for 30 years and that the procedure had been applied didn't mean that the court itself could not intervene. And I refer your lordships finally to the judgment. It is Ferdinand James and Clan Byron Caribbean Practice Limited. It's actually a St. Lucia High Court decision 2009-0776. And I'm asking the court to adopt the approach in paragraph 29, and it might be a good note to end our submission. The learned judge said not only is there some attractiveness to this argument, but also in practice, this is how it has worked for over 30 years, apparently without any confusion or uncertainty. As Ms. Francis points out, no judge of the Eastern Caribbean Court of Counsel has challenged this practice. Indeed, it might be said that the finding now of implied repeal would introduce uncertainty and disruption of a functioning system. Be that as it may, when it comes down to the forensic crunch, the court must give effect to the clear and unambiguous will of a sovereign parliament that jurisdiction to decide prescriptive title to land in St. Lucia vests in the registrar. The legal challenge to the rules having finally come, it cannot be ignored. To allow it to stand, even in the face of irreconcilable conflict with the LRA, because it might unleash a torrent of challenges to declarations of title granted under the rules, would amount to an abdication of the judicial responsibility to interpret and apply laws validly enacted by a legislation. So we are saying, my Lord, that if the High Court might have wrongly the Limitation Act as treated in the decision cited by counsel, this is an opportune time for the Caribbean Court of Justice to correct the wrong by identifying that the applicable law is as applied in Rosalie against George and Rosalie Estates, to recognize the certainty of the current system, the Title by Registration Act, and to ensure that the average citizen knows that if I have my land paper, I have greater rights to the land than you. So the registered proprietor has his paper. He knows that he has an indefeasible title. If some squatters on it without a paper, knowing that the registered title has a better, he will apply for his paper too. Make life certain, make the system simple, and ensure that the average citizen can access and understand the law. Not to go into the bosom of William III and IV to find out whether or not his title is extinguished. And the last point that we would like to make, we are not saying that the real... Sorry.
Go ahead. Last point.
I don't know the court is pressed for time, so I don't want to make one simple sentence. We are not saying that the Real Property Limitation Act does not apply. We are saying that it does not apply so far as it as registered land is concerned, where it conflicts with the policy of the Title by Registration Act, where it provides for automatic extinction of title, where it provides for a situation where, as in Mr. Simon's example, somebody is on the land for 12 years, another one is on the land for 8 years. The one that was there for 12 years dies. Mr. Simon says the registered proprietor can go after the one for 8 years. But the effect of the Real Property Limitation Act is that whoever was there for 12 years would have extinguished the registered
The title
proprietor's
of the
title.
paper owner. Yes. So that the 8-year man would still be able to prevail. There's one question I want to ask you before you close, and that is this. If the Section 33 procedure is engaged, but in the meantime, successfully engaged, but in the meantime, the previous certified title owner had encumbered the property, had mortgaged it, I am assuming, I'm asking, is it that the squatter would get a new title subject to those encumbrances?
I would expect so, because the encumbrances will be attached to the land.
Yes.
But from a practical point of view, what would normally happen is before the squatter challenges the title, provided that the title is not encumbered, he would file a caveat to prevent any dealings with the land until such time as the court decides the matter.
Fair enough. But before any such caveat had been filed, any such encumbrances would be valid, even if the certified title owner subsequently loses his title to someone who engages the Section 33 process.
Yes, certainly, because
it seems logical to follow.
The Act itself, the Title by Registration Act, provides that the rights of the registered proprietor may be qualified by mortgages and encumbrances. Once they are registered on the certificate of title.
Yes. All right, thank you very much, Mr. Bruni. Mr. Simon, do you have anything in response? You would need to unmute or perhaps...
Yes, I am now unmuted. Respectfully, the cases which my learned friend has quoted deal in the main with action being initiated by the squatter. We have not initiated this action. the respondent is the one and we are not claiming that the title of the respondent has been extinguished.
But that, but doesn't the William the Fourth law, which you say is incorporated in the RPLA, and which is incorporated into the RPLA, that's what it says. It says that the title is extinguished after 12 years.
But as against the appellant, it is as against the appellant only. And that is why the Title by Registration Act makes provision in section 33 for the appellant now to apply to get a title which would be a title that stands up to the whole world. So in this particular case, all the appellant is saying is that section 2 of the Limitation Act prevents you from bringing such an action because I have been in possession for more than 12 years. And that has been accepted by the parties. The fact of the appellant's occupation understood. And that's all we are saying. You see, what has happened is that both the respondents' counsel and the court have gone into a long discourse in respect of the application of section 33. We, the appellants, are saying we have not triggered section 33.
Yeah, I understand you.
And that's where our point is.
Okay, just one slight thing, Mr. Simon. On your argument then, there is the, if you want to call it paper title, in the registered proprietor of the land. And you're not challenging that, so he has a title. But you're saying that your client also has a title. It's not declared, it's not official, it has not gone through the registry, but he has a title. He can, I assume, therefore, encumber the land using that title as security, can he not?
No. The Real Property Limitation Act does not give you a paper title. And that is why section 33 indicates that once you can establish that you have a Real Property Limitation Act title, then you must go and get the paper title under the Registered Land Act.
Okay, so he can only use it as a shield, as you say. He can't, because I was a bit concerned about the implications of two persons having title to the same property. But you have alleviated some of my concerns.
Only as a shield.
Yes,
only
okay.
insofar as, nothing more than that. And that is where we stand, and that's the stop.
Okay.
So now how was it again that, let's say if this was not registered land, unregistered land, then section 2 of the Real Property Limitation Act says after 12 years of adverse possession, the paper owner cannot sue anymore. So that is one thing. Then section 10 says that even his title is extinguished. So how, under that system in Dominica, how does the squatter get title? Because it only says, well, the paper owner cannot sue him anymore, cannot get him out because 12 years have passed. And section 10 says his title even extinguished. But that doesn't mean that the squatter has a title yet. How does he get that under that system?
Muted again.
You're muted again, Mr. Simon. I don't know if it's at our end or your end, but we're not hearing you.
Not in your end.
Yes.
Yes. Do you accept responsibilities, sir? Yes. So the point I was making is under the common law system of titles, once the squatter can establish that he has been in possession for more than 12 years and acquired that title, then he would go further and, by counterclaim, claim and make claim for the title of the land. That's what would be under the common law system.
Okay.
With the Title by Registration Act, Section 33 provides the process
Sure.
by which the squatter would obtain.
Sure, understand.
Okay.
Yes. Okay, well, I think we've had some interesting submissions. We're going to take some time. I take it that whoever is unsuccessful, the question of costs. Would basic costs be reasonable in this case, so that the unsuccessful party will provide to the successful party what the CCJ's rules describe as basic costs?
If I may, before, I'm not sure if I'm being heard.
Yes, Ms. Dyer?
Yes, if I may, I'm sorry to interject at this point. Apparently, there was some difficulty with my connection. But what I wanted to just bring to the fore of the court's mind in response to a question asked by the honorable judge as to whether there is legislation or whether there is a case indicating the applicability of the Real Property Limitation Act to registered and unregistered land, I would refer the court to the case of Russian Bartholomew at page 1588 of 1807 of the record, which is a case emanating from the jurisdiction of Dominica. And in that case, the learned trial judge at paragraph 130 thereof expressly indicated, and if I may be permitted, it is found at page 1620. He said, in the face of the attributes of indefeasibility, evidence in the Title by Registration Act, and especially section 8, 10, and 33, plus the definition of indefeasibility contained in the first schedule to that act, section 2 of the Real Property Limitation Act can still prevail to permit a person to obtain title to land by adverse possession. And at paragraph 131, he went on to hold the immediate consequence of the provision, and the provision under analysis was section 2 of the RPLA. He said that the immediate consequence is that it makes no distinction between registered land and unregistered land. It speaks of land which is not defined. And when resort is had to section 2 of the Interpretation and General Clauses Act, land is defined inclusively to include buildings and other structures, land covered by water and any estate, interest, easement, servitude or right in or over land. In short, section 2 of the Real Property Limitation Act is at large, and section 2 thereof is no exception. So I would respectfully submit in answer to the court's question that the courts in the Commonwealth of Dominica have held the applicability of the Real Property Limitation Act to both registered land and unregistered land. And finally, it's unfortunate that there was a problem with my microphone.
No, we deliberately muted it so that we would avoid the feedback. But you have a senior counselor who's arguing on your behalf.
Yes, I'm sorry.
But Ms. Diamond, you want us to look at the case of Bartholomew and Bartholomew, is that it?
Yes, and also there is the case from the Privy Council of the Belize Estate and Produce Company Limited, in which the similar arguments analogous to what is occurring at the case at bar were considered. And the court held that the limitation...
Ms. Diamond, we can't have two addresses from the appellant. If you want to simply cite us some cases, then we would take the cases and we would read them. So the second case, what's the name of the case from Belize?
It's the Belize Estate and Produce Company Limited, and it is found at page 1644 through to page 1649 of the record.
Okay.
Okay, thank you.
Excellent.
Thank you very much.
Yes,
And what else?
If I just may refer the court to the High Court decision of, I will just cite the page, the High Court decision of Burton Revere, paragraph 20, which is found.
Yes, that's referred to in your submissions.
Yes, the High Court decision, yes.
Okay, thank you. Now, I was on the issue of costs, whether council have agreed among themselves or can agree that this case will be governed at the CCJ by basic costs being allowed to the successful party. Is there any, I don't know if the mics are muted, but
on course, the mic's always muted, sir.
yeah.
If I may say, I'm not very knowledgeable in respect of the issue of costs. Unless if the court would like to give council the opportunity for us to discuss the matter, and then we could write or just make joint submissions in respect of that.
Yes, okay. We will defer the issue. Thank you again for your submissions, and we will adjourn and let you know when we are ready with the judgment.
All right.